I am Hank Chambers. I'm a law professor down at the University of Richmond.
Hello, my name is Thomas Mackey. I'm in the history department at the University of Louisville and the Brandeis School of Law at U of L.
Good morning. My name's Rita McCannon. I'm a lawyer in Huntsville, Alabama, and I'm so proud of you all for taking the time to prepare and to work on this and to be here today.
Hi, my name's Alexa Back. I'm currently a junior at Greenwich High School, and I'm in the We the People program.
Good morning. My name is David Katz. I'm a junior at Greenwich High School enrolled in the We the People program.
Hi, I'm Chris Walko. I'm currently a junior at Greenwich High School in the We the People program. And today we have with us Coach Hull, Coach Moore, and Coach Hamry.
That's fantastic. It's great to see all of you all here, and we are so very proud of you guys, and good to see you. So we'll get into Unit 3. Question 3. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? We are ready for your opening statement.
In March 1776, Abigail Adams asked her husband to remember the ladies while crafting the Constitution. However, federally, women would not be remembered until the 19th Amendment, which gave them the franchise. Following this, women became more politically active, playing a pivotal role in the passage of the Shepherd-Towner Act, which pushed for funding towards childcare and maternity leave.
Following World War II, laws such as Title IX of the Education Act and Title VII of the Civil Rights Act declared that equality in education and payment. Indeed, the 19th Amendment was pivotal in the women's movement as it provided women with legitimacy to advocate for equality. Globally, America was late in allowing women's suffrage. Countries such as New Zealand, Canada, and the UK allowed women to vote earlier. While American suffrage had no real impact on the international community, it marked a major event in the global trend towards equality. Yet, there's another amendment which strove for equality. The ERA was proposed in 1923 and declared that, quote, equality of rights under the law shall not be denied or abridged by the United States or by any state on the account of sex. Both the ERA and the 19th Amendment were opposed due to their meaning of advancing equality. This is due to the antiquated tradition of Republican motherhood, which emphasizes a woman's role in the domestic sphere. Even women fought against ratification, with Josephine Dodge and Phyllis Schlafly arguing for this outlook. Yet, activists were able to overcome these restrictions for the 19th Amendment due to the fact that it's much more narrow than the ERA, simply advocating for the franchise.
There are disadvantages to a national ERA. Firstly, the establishment of the ERA would not have an imminent legal effect. Even acclaimed constitutional scholar Michael Klorman, who supports the ERA for its symbolic value, claims that it is not clear that the ERA being law changes a single outcome of any litigated case. This is due to the existence of the Equal Protections Clause, which states that no state may deny to any person within its jurisdiction the equal protection of the laws. Since the 1970s, this has been used to oppose sexual discrimination in cases such as Reed v. Reed, which stated that giving mandatory preferences to members of either sex over members of the other is forbidden by the Equal Protection Clause. This precedent was expanded upon in J.E.B. v. Alabama, which ruled that one cannot remove jurors based on gender, and U.S. v. Virginia, which held that a male-only admission policy in military schools was unconstitutional. Indeed, these are the same legal rights that an ERA would protect. Additionally, critics have argued that the ERA could lead to an expansion of federal power. The second clause of the ERA states that Congress and the several states shall have power to enforce by appropriate legislation the provisions of this article. People have claimed that this would allow Congress to further accumulate power, allowing broader legislation in areas like family law, which was traditionally reserved to the states.
However, a national ERA is necessary as a symbol to demonstrate America's commitment to equality. Justice Ruth Bader once said, quote, I would like to be able to take out my pocket constitution and say that the equal citizenship stature of men and women is a fundamental tenet for our society, like free speech, end quote. Indeed, the Constitution is not purely a legal document, but rather, as acclaimed constitutional scholar Sanford Levinson states, quote, the central covenant of the American community, end quote, a statement of what makes us truly American. Therefore, without a facial statement of equality, can we really say that we have progressed? Discrimination still persists with the Equal Protection Clause in regards to sex as observed in U.S. v. Morrison, where a section of the Violence Against Women Act was struck down in spite of the vital protections it provided women against sexual assault. If people can still get away with that under our supposedly equal society, it is clear that we have not gone far enough. Therefore, while the Equal Protection Clause is useful, the United States needs the ERA in order to cement the principle that was established in the Declaration of Independence and was altered at Seneca Falls, that quote, all men and women are created equal, end quote. Thank you. We now stand ready for questioning.
Thank you very much. Do you agree with Michael Klarman that the ERA would do nothing more than the Equal Protection Clause of the 14th Amendment?
We do in part agree with Michael Klarman. We believe that case law precedents set in the 70s and the 80s under the Equal Protection Clause of the 14th Amendment would not change if an ERA was ratified. It would only change cases in the future, maybe, and other types of law.
Yeah, and that being said, I think the greatest effect of the ERA is if you look at the actual protections acquired under jurisprudence in cases like JEB v. Alabama and US v. Virginia. I don't think any of that would change. The case that I think is the most interesting to look at is US v. Morrison. In that case, a provision of the Violence Against Women Act was struck down under the Commerce Clause, because the Commerce Clause, this was coming off the heels of cases like US v. Lopez, Prince v. US. They said that the Commerce Clause it was an overreading of the Commerce Clause to allow the Congress to legislate against gender-based violence. If an ERA was passed, that would be a statement in the Constitution that would allow Congress to pass those laws without challenges in the court, which would lead to further equality.
And this clause of the Violence Against Women Act would certainly be upheld, and it would be reintroduced, and this specific clause allows women to sue their attackers in federal court.
So help me out here. So the ERA, isn't that supposed to get sex and gender out of the law? So wouldn't the Violence Against Women Act be explicitly not allowed under the ERA?
Right.
So the thing is that the ERA says that the right should not be abridged on account of sex. And there are some rights that are abridged on account of sex just because women are women. For example, I would say that, under the right to life found in the Declaration of Independence, you have a right to be prevented from being assaulted, like was the case in US v. Morrison. So therefore, in order to protect that right and enshrine that right, they would be able to legislate protections for women so they would not be attacked like that.
Okay.
Yeah, interesting. Because part of what I'm hearing is a cultural argument about men and women and treatment of individuals, and yet the questions about a constitutional amendment and a structural change. Help me understand this relationship, if any, between legal change and cultural change.
Well,
go ahead. I'm sorry, Ms. Black.
I'm sorry. We did bring this up with constitutional scholar Sanford Levinson, and how the Constitution that we argue is also used for symbolic value and how it represents our society as a nation. And so the culture shift that we're arguing here today is that the ERA will allow women to actually come forward and with even cases such as like US v. Morrison, and actually come forward and share their cases of discrimination. And it will actually help solidify the fundamental value that men and women are equal in the United States in order to keep that symbolic representation in our society.
Yeah, and today we see over 83% of sexual harassment charges are filed by women in the workplace. So not only passing the ERA, it would help with symbolic importance, and it would sort of, you'd be able to look directly at the Constitution and say that, hey, women are exactly equal to men, and stuff like sexual harassment should be a lot lower for women.
Yeah, and that translates into, as I said earlier, an enumerated power of Congress. Not only what, as Justice Ginsburg said, you'd be able to say, the equality of men and women is a fundamental tenet of our society, but also Congress would then gain the power to legislate further on issues that further the equality for women.
Great. So help me out here. You all mentioned Title VII, which already makes sexual harassment unlawful. So what is it that the ERA would do in order to solidify the laws that we already have, or would it just solidify them?
Well, as we said in our statement, the Equal Protection Clause is not enough. We still see examples of discrimination persist. For example, my own mother, she was discriminated against in her old prior workplace, where she was made sexist remarks towards, and she actually and was told, maybe you should not have another child, which was me, and I was actually denied tenure, and she actually sued them, and she sued them under the Equal Protection Clause. And she actually lost the case, but due to the case, many other people came forward and actually discussed that they were being discriminated against in their own workplace.
Yeah, the Constitution as a document is so fundamental to our society. It's the supreme law of the land, whereas Title VII and Title IX, they're all fantastic, but they're just the law of the land, and they can easily be taken out if there was some sort of political change in the Congress. The thing that's so amazing about the Constitution is it would solidify it as a founding principle, which if we're truly going to say that we are the arsenal of democracy, to quote Franklin Delano Roosevelt, we need to have that solidification of equality in our Constitution, our highest document.
And we're running out of time, and I wanted to ask you about elections and why women had not been able to attain higher office, and he's already put up the 1 minute sign, so I'm not going to get into that. What you were saying, Alexa, about U.S. v. Morrison also is that this gives women an equal footing to men because men have been being protected from anything happening to them because of not having equal protection for women.
Yeah, so, well, yes, we say that like men and women, sorry, is it okay if I answer?
Please.
Okay, so if we say that men and women are equal in our society, we have to support the fact that in our Constitution that men and women are equal, and provisions that were stated in U.S. v. Morrison saying that women are not able to sue their attackers in federal court, and that being put down due to the Equal Protection Clause. And due to the in the 14th Amendment, you have to support that in order to solidify that women should be able to sue their federal attackers in court. And surely that provision in U.S. v. Morrison would change if the ERA was ratified.
Okay, thanks. Good job.
Good job. Good job. So comments from my fellow judges.
Yeah, I thought this was an interesting take on this question. It's a tougher question than it seems at first read because it is both constitutional issues, legal issues, but what we ended up talking about a lot was cultural issues and values. And it's an interesting mix of both law and social and cultural values trying to at play in this question. Wanted to remind folks, somebody's talked about life, liberty in the Declaration of Independence. Can't litigate that, but it is in both the Fifth Amendment and in the 14th Amendment. I think it was just a misstatement. So you want to be a little careful there. I understand the impulse to go to the Declaration, but just be a little careful. And if that's what I have to nitpick about, then it's a sign that you did a really nice job.
Yeah. Rita, what you got?
I'm just turning it over and over in my mind. They gave me so much to think about, and y'all actually put the answers to the question in a different light than some of the other groups did. I guess that's why I fumbled my last question so badly. I thought it was great that you brought U.S. v. Morrison out, and you talked about it so very much and on a personal level. You know, we're always asking you to give us evidence, and you had it. You had personal evidence, which I think is fascinating. And for once, we didn't just bear down on Alabama court cases, although I did hear one that I don't think I've heard before. My state seems to be rather talented at coming up with the things that on a regular basis. I'm just real impressed that you all have absorbed what the impact of these things can do. And I hope, Alexa, that you're prepared to run for office someday.
Oh, thank you.
It's good. It was a good conversation. Here's you all had a lot of good ideas and a lot of good ways of pulling things together. We did end up talking about a lot of cultural issues, and here's why I think we ended up talking about cultural issues, because a lot of the specifics that you all gave are already covered in law. So it had to be the case that the ERA is essentially symbolic. If you disagreed with Klarman, that'd be one thing. But once you agree with Klarman, you're essentially saying the ERA is not going to do anything. So if you add that to the notion that we already have Title VII, which covers a lot of what was talked about, and when you add that to the notion that the Violence Against Women Act had to do with the Commerce Clause, not the ERA, it really becomes symbolic, which then raises the question, we've had symbols in our law for hundreds of years. If you go back to the Declaration, if you go back to Seneca Falls, if you go back to Abigail Adams, and it does raise the question, what's it going to take for us to get through our skulls that we need to treat women equally? Will it take another amendment, or will it take someone walking up to folks and just knocking them on the head and saying, you know, women are equal, right? So it becomes a tough issue, but I think y'all handled it well. And with luck, you all will keep pushing in this direction because it's your responsibility to solve, because my generation has already messed it up. So congratulations, you get to solve it. Come on back and tell us how you all have fixed it, and we will appreciate it quite a bit. So, but good stuff all around, and it's good to see you all, and it's good to see you all are working even in these days of social distancing and being away from school a fair amount. So thank you all very much, and thank you all very much to your teachers as well.
Right.
Good job. Thank you, Ms.